Virginia's assault weapons ban has officially been signed into law. The governor acted within her 30-day window after the legislative session ended on March 14th. That means the clock is real, the fight is real, and the window you have left to act is closing faster than most people realize. Today we are going to break down exactly what these laws do, what they don't do, and 5 concrete things you need to do before July 1st, 2026 when they take effect. Not vague advice, not panic. Specific, strategic steps that I've already done myself for my own family. Before we go any further, if this is helping you think clearly about a situation that feels chaotic, hit subscribe right now and turn on notifications. The analysis coming after these laws hit enforcement will be worth more than anything you buy between now and the deadline. You do not want to miss it. And drop a comment below with your biggest concern, because those questions shape what we cover next. Let's start with timeline, because a lot of people are misreading it. The effective date is July 1st, 2026. That sounds far away. It is not. Between now and then, you have a narrow window to acquire, assemble, and document everything you want to own legally under these new rules. After July 1st, the rules on new acquisition change dramatically. You keep what you own before that date. That's the critical distinction. Possession is not banned. What gets banned after that date is acquisition, manufacture, importation, and certain transfers. If it's already in your safe before July 1st, 2026, it stays yours. Everything after that date becomes a much harder conversation. Now let's get into exactly what the law covers, because every word matters when we're talking about criminal liability. I'm going to read you the actual categories so there's no confusion. First, any semi-automatic rifle or pistol, and yes, this covers both centerfire and rimfire, I've verified the text, with a fixed magazine holding more than 15 rounds. Second, semi-automatic rifles with detachable magazines that have any one of the following features: a folding, telescoping, or collapsible stock, a thumbhole stock or pistol grip that protrudes conspicuously beneath the action, a second hand grip or protruding grip for the non-trigger hand, a grenade launcher, or a threaded muzzle, one feature from that list, plus a detachable magazine, and you're in banned territory. Third, semi-automatic pistols with 2 or more of these features: a second hand grip or protruding grip for the non-trigger hand, the capacity to accept a magazine that attaches outside the pistol grip, a barrel shroud that lets you hold the pistol with your non-trigger hand without being burned. And that language around "without being burned" is going to need litigation to clarify. A threaded muzzle, or a buffer tube, arm brace, or anything protruding behind the grip designed to allow shoulder firing. 2 features from that list and your pistol is prohibited for new acquisition after the deadline. Fourth, semi-automatic shotguns with folding, telescoping, or collapsible stocks, thumbhole stocks, pistol grips, detachable magazines, or fixed magazines over 15 rounds. Fifth, shotguns with revolving cylinders. Sixth, belt-fed weapons. And finally, magazines, excluding tubular .22 magazines, holding more than 15 rounds. Those are now defined as high-capacity magazines under Virginia law. Here's the timing that should sharpen your focus. Just weeks ago, the D.C. Circuit Court of Appeals ruled that restricting magazines over 10 rounds is unconstitutional because those magazines are in common use. Virginia is moving forward with a 15-round limit, while its neighbor is saying even a 10-round limit goes too far. That ruling is persuasive authority. It is not binding on Virginia courts, but it is the ammunition, no pun intended, that litigation groups are already loading up for the challenges ahead. That fight is coming, but litigation takes years, and the law will be on the books the entire time. You cannot live your life banking on a court saving you before the deadline. You act now, and you fight simultaneously. Now here's the distinction that will trip people up the most, and I need you to understand it before we get into the 5 steps. The law treats banned firearms and banned magazines differently when it comes to what you can do with grandfathered property after July 1st, 2026. If you own a covered rifle before the deadline, you can loan it to someone, you can sell it to your spouse, parent, grandparent, sibling, or child. You can pass it through inheritance. The weapon stays in circulation within your family network. Magazines over 15 rounds, entirely different story. Even if you lawfully possess them before the deadline, the same transfer flexibility does not apply. They effectively die with you legally unless you plan ahead. Which means if you want your children to have functional firearms long term, you need a magazine strategy right now, not in 6 months. That leads directly into step 1. Buy the firearms. If you've had your eye on an AR-15, an AR-10, a feature-heavy pistol, or any configuration that falls under these definitions, the acquisition window is open right now and it is closing. After July 1st, 2026, your only legal options for obtaining a covered firearm are inheriting one or getting a close family member, spouse, parent, grandparent, sibling, child, to sell or gift you one from their pre-ban collection. The general market closes. Prices are already moving. Inventory is shifting. I'm not telling you to blow your budget. I'm telling you to calculate the cost of never being able to acquire that platform legally again in this state. For most people, that changes the math entirely. Step 2 is magazines. And this is where the law's own drafting creates an opportunity the legislature almost certainly didn't intend. There is no age restriction on magazine possession in Virginia. None. The law restricts firearm possession by age. Magazines are different. A child can legally possess a magazine, which means you buy magazines now in your children's names, you ship them to your children's addresses, you leave them sealed in the box, untouched, stored safely. When your child reaches the legal age to possess a covered firearm, whether that's 18, 21, or whatever the law says at that point, you transfer them a grandfathered weapon through the permitted family channels, and they already own the magazines to run it. They possessed those magazines lawfully before the deadline. You didn't transfer prohibited property after the cutoff. They simply owned them all along. I've done this myself. I have young kids. I have magazines sitting in their names, in sealed boxes, waiting. It is the single most overlooked planning step I see Virginia gun owners skipping right now. Step 3 is completing your builds. If you have stripped lower receivers sitting in your safe, or you've been accumulating components and planning to finish the build later is now, after July 1st, 2026, there is a serious legal risk that courts could interpret attaching an upper receiver to a stripped lower as manufacturing a prohibited weapon. The bill does not define manufacturing. That undefined term is exactly the kind of gap prosecutors will try to exploit and exactly the kind of gap you do not want to be the test case for. Get your builds done before the deadline. Get them into their final configuration. Document when you did it. We'll get to documentation in a moment, and remove all ambiguity. The mechanical act of assembly needs to happen before July 1st, 2026, full stop. Step 4 is setting up a firearms trust, and this is where the legal structure gets genuinely powerful for long-term family planning. A properly drafted firearms trust does two things under Virginia's new regime. First, it creates a legal entity that holds your covered weapons and magazines with more flexibility than individual ownership allows. Second, it lets you designate multiple co-trustees who have present possessory rights to trust property, not future beneficiaries waiting for inheritance, but current lawful possessors. That distinction matters because the law restricts transfers between individuals, not simultaneous lawful possession by multiple parties within a trust structure. Here is how you build it. You create the trust, transfer your pre-July 2026 covered weapons and magazines into it, and name yourself trustee. You name successor trustees who step in automatically if you die or become incapacitated. You name co-trustees, your spouse, your adult children, trusted family members who have present access to trust property. If something happens to you, the firearms don't sit in legal limbo waiting for a prohibited post-ban transfer to clear. They remain in the continuous lawful possession of the trust, administered by your successors. You amend it over time as circumstances change. The flexibility is the entire point. The trust also creates an argument around magazine distribution that individual ownership doesn't. The law says individuals cannot transfer high-capacity magazines to family members the same way they can transfer the firearms themselves. But the law is silent on what happens when a trust distributes assets to beneficiaries upon the settler's death. That silence is arguable territory. Put the magazines in the trust, document them as trust property, create the paper trail that shows lawful pre-ban possession held in trust and distributed according to trust terms, not transferred in violation of statute. I'm not telling you this is bulletproof. I'm telling you it gives your heirs a defensible position, which is more than they'd have without it. One more thing on trusts. The law lists permitted family transfers as spouse, parent, grandparent, sibling, or child. It does not list stepchildren, in-laws, domestic partners, or cousins. If your family structure doesn't fit that statutory list, a trust becomes even more critical. Your partner of 20 years who you never married, not a statutory family member under this law, but they can be a co-trustee with present possessory rights. They can be a beneficiary. The trust creates legal relationships that the statute recognizes when the statute's own definitions would leave the people you care about without access. Step 5 is documentation, and this is where most gun owners completely drop the ball until it's too late. Owning something before July 1st, 2026 and being able to prove you owned it are two entirely different things. In a criminal prosecution or civil forfeiture proceeding, the burden of proving lawful grandfathered status will fall on you. The state will assume your AR-15 was acquired after the ban. You have to prove otherwise. The minimum you should be doing right now is building a detailed inventory. Serial number, manufacturer, model, date acquired, source. Photographs of every firearm with the serial number clearly visible. Photographs of magazines showing base plates, capacity markings, manufacturer stamps. Email these to yourself. Use a cloud service with timestamp preservation. The email creates a time-stamped record that is difficult to fabricate retroactively. Is it perfect? No. Is it infinitely better than relying on your memory 3 years from now when a prosecutor is asking questions? Yes. Go further than that if you can. Record video, walk through your safe with your phone, and narrate what you're showing. Serial numbers, configurations, magazine counts, upload it to cloud storage, email it to yourself. The video format is harder to fabricate than photographs, and the narration creates contemporaneous explanation that removes ambiguity. Do this before July 1st, 2026, and update it periodically to show continuous possession. The strongest protection is a privileged attorney file. When you establish an attorney-client relationship and provide your firearms inventory with photographs and acquisition documentation, those records are maintained under attorney-client privilege. That means they cannot be subpoenaed without your consent. They cannot be accessed by law enforcement without a process that gives you notice and an opportunity to object. If you're ever charged with a firearms violation, you have pre-existing, dated, privileged records of your lawful possession before the cutoff. The prosecution cannot compel your attorney to testify against you about what you showed them. The privilege is yours to waive or assert. It is the most protected form of documentation available under American law, and it is exactly what you want standing between you and a prosecutor trying to claim your pre-ban property was acquired illegally. I know what some of you are thinking. I don't want a government list of my guns. That's a legitimate concern, but here's the reality. You are already on lists. NICS checks create records. 4E473 forms exist. Credit card transactions for firearms purchases are retained by financial institutions. The question is not whether records of your firearms exist. The question is whether you control the narrative when those records get used against you. A privileged client file with an attorney is the one form of documentation where you do control that narrative. The alternative, relying on your memory, your dealer's records, your bank's goodwill, is hope, not a strategy. Let me give you the big picture before we wrap up, because this isn't just about scrambling before a deadline. What you're building between now and July 1st, 2026 is a defensive legal position that survives the next decade of Virginia gun law, however the courts eventually rule. Multiple litigation organizations are already preparing challenges. The magazine restriction is the most vulnerable provision. Millions of magazines over 15 rounds are in common use by law-abiding citizens, law enforcement, and military personnel. That is the exact standard the courts have used to strike down similar restrictions elsewhere. The D.C. Circuit just reinforced it. Virginia's ban will be challenged within months of taking effect, and those challenges have real teeth under Bruen and Heller. But even the fastest court victories take years to materialize. You need to survive the interim period legally intact. The assault weapon features test will be harder to challenge but is not invulnerable. Threaded muzzles are standard accessories for suppressors, which are themselves constitutionally protected under current doctrine. Pistol grips are ergonomic, not tactical. The features the legislature chose to ban reflect aesthetics more than function, and that is exactly the argument courts will evaluate under Bruen's historical tradition requirement. There is no founding-era tradition of banning rifles because they have a certain type of grip or a muzzle device. We will argue that. The litigation is coming. In the meantime, your job is to act in the window you have, buy what you want to own, buy magazines for your children now, finish your builds, get your firearms into a trust with properly designated co-trustees and beneficiaries, and document everything with a paper trail that can survive a prosecutor's review. Virginia gun owners have been through hard legislative moments before, and they've come out on the other side more than once. The key is staying informed, staying prepared, and staying organized. Do these 5 things while you still have the time to do them correctly, and you will be in the strongest possible legal position when July 1st, 2026 arrives, and for everything that comes after it. If this video helped you think more clearly about a situation that feels overwhelming, hit that like button and share it with every Virginia gun owner you know. Subscribe with notifications on, because the moment these laws hit enforcement and the first court filings land, we'll be back breaking down exactly where the legislature overreached and where the courts are likely to step in. There is a lot more coming. You don't want to miss it. Before the next video, let me address a few gray area questions I am already getting constantly, because some of you are sitting on specific situations that the 5 steps alone do not fully answer. Arm braces versus stocks. The federal ATF has reversed its position on this multiple times. Virginia's law references buffer tubes, arm braces, or any other part that protrudes behind the pistol grip and is designed to allow or facilitate shoulder firing. If you have a genuinely braced pistol with a stabilizing brace designed for arm use, the manufacturer's design intent and original classification matter significantly. But if you have been shouldering the brace regularly, if you have modified it, or if the overall configuration strongly suggests shoulder fire use, you are in risk territory. My advice is straightforward. Photograph your braced pistols now in their current configuration. Document the manufacturer's specifications. Do not modify them after July 1st, 2026 in ways that lean toward shoulder fire redesign. If you want a stocked configuration, get your builds completed and documented before the deadline, or go through the federal SBR process while there is still time to do it cleanly. Feature combinations on pistols. The law uses a 2-feature threshold for semi-automatic pistols. The statute says the weapon must have the capacity to accept certain features. It is about the design, not your parts bin. but prosecutors have argued constructive possession in other states. If you have the parts and the weapon together, you have the functional combination. The safest move is to segregate your accessories. Pistol grips, braces, threaded muzzle devices you have not permanently attached, store them separately from completed weapons. Document your pre-ban configurations precisely. Do not hand an investigator an easy visual argument that you had a 2-feature pistol sitting assembled in your home. Interstate inheritance. Let's say a family member in another state passes away and leaves you their firearms collection, which includes weapons that would be banned under Virginia law. Can you bring them home? The law has an exemption for transfers by inheritance, but it does not clearly address interstate inheritance of banned weapons. Federal compliance does not automatically equal state compliance here. This is unsettled territory. Contact an attorney before you take possession of anything across state lines. The conservative approach is always to verify before you act, not after the fact when the legal exposure is already locked in. Now, for the question that lands in my inbox every single day. Do I stay in Virginia and fight, or do I leave? I am not making that decision for you. But here is the honest framework. You stay if your roots, your work, your family, and your community are here and you can absorb the compliance costs. The ban is genuinely frustrating. It is also survivable with preparation. The litigation will continue. Political change in Virginia is not impossible. The same legislature that passed this can be voted out. Your presence, your organizing, and your activism matter more here than anywhere else if you stay and engage. You leave if your firearms collection is central to your primary hobby or livelihood, if your work is portable, if your family is willing to relocate, and if you have found a destination that does not impose these restrictions. Texas, Florida, Tennessee, and several other states have no comparable bans. The freedom difference is real. Neither choice is wrong. Make it with clear eyes rather than in a panic. The complete plan stated plainly looks like this. Between now and July 1st, 2026, own what you want to own, assembled, documented, and trust held if possible. After July 1st, maintain your grandfathered property, support the litigation financially and organizationally, vote in every election that shapes the legislature, and train your successors so they are not starting from zero when they inherit this fight alongside the firearms. The weapons themselves are hardware. The knowledge, the legal structures, the political will, and the documentation systems you build right now are the enduring assets. Every one of those things lasts longer than any individual firearm. Build all of them while the window is still open, because once July 1st, 2026 arrives, the only people who will be in a strong position are the ones who use this time well.